Lawyers, can you describe the moment you realized you were going to win your case? Story 1. It was my third month of practice, and I was in family law at the time, representing a mother in a petition for a restraining order against her boyfriend, who was also the father of her child. At issue in the broader case was child visitation, custody, support, etc. But today's hearing was just for the restraining order. We had pretty good facts, but it was mostly based on the testimony of the parties. My client was far more reputable as a witness, so I was feeling confident. 10 minutes before the hearing, my client showed up. I gave her a last-minute prep on what to expect. Then she said, "I'm glad I'm going through with this. I can't deal with it anymore, and he's just getting worse." To top it off, he left me a drunken, ranting voicemail on Saturday. So, I asked if she had the phone with her, and she did. We played the voicemail, and it was a full 2 minutes of her ex-boyfriend screaming things like, "I should have unalived you when we were together. You are always such a female dog. I hope you burn to death in a fire." I didn't have time to ask her why she hadn't mentioned the voicemail before the bailiff called our case. We sat, and the judge asked if either side had additional evidence. I asked for permission to play the voicemail. The ex-boyfriend, who didn't have an attorney, didn't object, so I played the whole nasty 2-minute rant in open court. The judge listened intently, then said, "We're going to take a brief recess before I issue my ruling. If the parties want to meet and confer in the hall, they're welcome to." The ex-boyfriend knew he was screwed. We settled the whole case then and there. My client got her wish list in terms of custody, supervised visitation, child support, and the restraining order. It was a huge slam dunk, and he was done even if he had an attorney after that point. Story 2. This isn't my story, but my mom's. She was fighting for custody on behalf of the father, trying to prove that the kids were living in subpar conditions with their drug-addicted mother, despite the ample child support provided. It was a tough case because courts are so hesitant to pull kids away from their moms. Then, the mom burst out that she had been feeding the kids cat food as proof that she wouldn't let them starve. Needless to say, the judge did not take that as a good reason for the kids to stay with their mom. My mom won the case, and the father gained custody. Story 3. I tried to sell my home myself, and the buyers wanted a term period for a land contract before getting their own mortgage. I agreed to 1 year and had a simple contract drawn up. After we both signed it, everything seemed fine. Within 30 days, they presented me with their own legally drawn-up land contract that was pages long to protect their investment. On about page 3, it very clearly stated that if, for any reason, the home burned down, the purchaser would receive all insurance proceeds first. I still had a mortgage, and the proceeds would legally go to pay that off. Secondly, that's a pretty targeted thing to say, not lawyers' terms of the house being destroyed, and it's surrounded by woods and waterways, just if it burnt down. Page 4 stated that this would remain a land contract until my mortgage was paid in full, so they would never buy outright. I returned it to them with a letter stating those two things were never happening, and I wasn't signing. They stopped paying, so I began eviction proceedings. 6 months later, the lawyer I hired was an idiot, and I'm sitting down with their lawyer myself. He brings out the contract they tried giving me and began talking about their ironclad case due to the agreement. I asked him to show me my signature. The look on his face when he realized it wasn't there was priceless. After we talked, it turned out he knew them and wrote the contract without the burn the house down stipulation. It seems they added it, believing it was a long-term land contract. Not only did I win, but I'm pretty sure they lost a lawyer friend. It was a weird play, and they were kind of just hoping their lawyer friend was bad at his job. Story 4. Not a lawyer, but I played one in small claims court. My lease had an exit clause that stated if I fronted 2 months' rent, they would work to lease my place and return anything unused. I checked with the office ahead of time, and they assured me there was a waiting list. So I gave them the 2 months and moved out. They never returned a dime. Determined to get my money back, I talked to the new tenant and confirmed they moved in a week later. In court, the judge was commenting on how he didn't see anything, explicitly saying they would return any unused rent, even though that intent was stated to me a few times. Dumbo from the leasing office piped up with, "Your Honor, in almost every case, we can return some money, but in this case, we didn't have a tenant in the 2 months after he left." The judge turned back to me, and I presented the affidavit from the new tenant, confirming the move-in date. The judge awarded me double what they owed. It turns out leasing office Dumbos 1 and 2 thought they could lie to me and pocket my excess rent money for themselves. It was a satisfying victory, especially against a dishonest landlord. Story 5. I was reviewing the transcript of an interview with a child who had made incriminating statements against my client. While reading, I noticed the child used an odd word when discussing the allegations. At first, I didn't think much of it. A few days later, I was watching a video of the child interacting with their grandmother, who despised my client. The video was from about a week before the interview. To my surprise, the grandmother used the exact same odd word in the exact context. The child later used it. In that moment, it became clear to me that the child had been coached. It was the first real aha moment of my career. The realization that the child's testimony was influenced by the grandmother changed the entire direction of the case. It was a significant breakthrough that ultimately helped to defend my client. Story 6. I had a client who was accused of taking a young woman's car, crashing it, and then fleeing the scene. The young woman testified at the trial, stating that she had given my client the keys that night because she was drunk and would never ever drive under the influence. She appeared confident, almost defiant, as she recounted her story in front of the judge. However, she was unaware that I had requested and obtained a copy of her driving record, which revealed a different story. A month after the incident, she had received a DUI. As I stood up, holding the document, I could see her face tighten. I walked over and handed her the driving record, saying, "Except that one time you got caught a month later, right?" Her face fell, eyes wide with shock and panic. The courtroom was silent, save for the judge who leaned forward, his eyebrows raised in surprise. The look on his face mirrored the disbelief I felt the moment I discovered the record. It was clear that her credibility was now in tatters, and the case was leaning heavily in our favor. Story 7. Not a lawyer, but a client in my divorce trial. My ex-wife spent about 2 hours explaining to the court what a piece of crap I was and all the horrible things I'd done to her and my children, claiming that I was unfit to be a parent. 2 solid hours of lie upon lie. Just 6 months earlier, my wife had snuck into my house, the one she'd moved out of, and went onto my computer to type me a love letter. "Oh, you're so wonderful. You're such an amazing father, great provider, great husband. You've done so much for the community. Please don't leave me." That's the gist of it. Well, she didn't print it or sign it. It was just a file on my computer left on the screen for me to find. Our challenge, after all her testimony to the contrary, was to get her to admit that she wrote the letter. I told my attorney, "Ask her. She won't be able to lie if she's sworn in, plus she's going to feel incredibly guilty about all these lies." So he handed her a printout. He had one too. He started reading it and asked her, "Do you remember writing this letter?" Her face was shriveling. She looked at her attorney and said, "I'm sorry, Sandy." Then she looked at the courtroom and said, "Yes, I wrote this." There was silence for a few moments. Then the judge said, "Attorney's in my chambers now." My attorney told me later that the judge understood that when my wife said, "I'm sorry, Sandy," it meant her attorney was aware this letter might be brought up and had instructed her client to lie. The judge was furious. Back in the courtroom, my attorney went down the list, lie by lie. Did he really do this? Did he really do that? When you say he was doing this, wasn't it really that? Etc. Then he had her read the entire letter again. After that, my divorce went from me being half an inch away from losing all custody and relegated to supervised visits to getting full custody. Made for TV or what? Story 8. We had no evidence that the woman who slammed into my stop car going 85 miles per hour was drunk until she indignantly admitted it on tape in her deposition. She burst into my deposition and demanded to go first because I was a lying female dog. She excitedly told my lawyer that the police report was wrong because it said she was coming from the movie theater when she was actually coming from her friend's bar. "Did you have anything to drink at your friend's bar?" my lawyer asked. "Of course," she replied. "How many drinks?" "I don't know. They just keep my glass full." "Did you take any medicine that day? Methadone and low blood pressure medicine?" I saw the cops had refused to breathalyze her at the scene because her husband was a firefighter they knew personally. They told her to go home, sober up, and go to the hospital later. I had heard the whole thing, but had no proof until she handed it to me in her deposition. They settled the same day. Story 9. So I filed the lawsuit in January, and we exchanged discovery, each side sending questionnaires and receiving carefully worded answers over the next few months. I filed a motion for summary judgment, asking the court to let me win the case without a jury because the case seemed so obvious. Right before filing this motion, I decided to review the discovery materials to see if there was anything I had missed. What do you know? The other side made a massive mistake on literally just the fourth out of the 100-plus questions I asked. It was a dog bite case, and every single time I asked about the bite, their response was along the lines of, "We admit to this and that, but we deny that our dog was involved in any dog attack." However, question 4 asked whether they admitted that their dog was not leashed on the day it bit my client. They simply answered, "Admit," meaning they admitted their dog was not leashed, and, crucially, that their dog was the one that bit my client. This was the one thing genuinely in dispute. They tried to argue at the hearing that it was a mistake, and they only meant to admit to the lack of a leash. However, the judge held them to their word, most likely because the other evidence made it clear it could only have been their dog anyway. I gotta admit, the wording on that is a little tricky. Of course, you're supposed to pay more attention when you're doing legal paperwork, but I could see how that could be used as a gotcha. Story 10. Years ago, I had to do something at a strip mall in a bad part of town. It took me about 20 minutes, and when I returned, I found my car had been towed. I took an Uber to the tow yard, only to find a giant sign that said cash only. I had to call another Uber to drive to an ATM and back to pay them $300. They handed me a crappy handwritten receipt, but it was itemized. When I got home, I Googled the laws and found out that they had violated the law in 3 separate ways: towing illegally, refusing to accept credit cards, and charging unreasonable fees like dolly fees and load-unload fees. I took them to small claims court. The judge began by asking the tow yard owner about his relationship with the property owner and how the decision was made to tow my car. The slimy Miami tow truck dude answered, "My cousin works there. If he says tow it, it's 100% legal." The judge's eyebrows began to rise. The dude continued, "But what I detest the most, Your Honor, is this jerk claiming that I don't take credit cards. I'm a businessman. I take credit cards all the time. He's a lowlife that does not have any credit cards. That's why he wanted to pay cash." I was having a hold it overload. The judge saw me smiling, hopping in my seat, and patting my manila folder of receipts. "Do you actually not have any credit or debit cards?" the judge asked me. I pulled out my wallet and showed him my cards, then pulled out a time-stamped photo of the cash-only sign I took the day of the tow and another one I took the morning of the hearing. The guy mumbled something like, "Okay, you got me there," and then went silent when the judge asked him about the legality of each unreasonable itemized charge. Each violation paid double the total tow charge, and since there were 3, I made $1,800 on a $300 investment. Story 11. I'm a trial lawyer, and I have a ton of these. My favorite was probably a DUI case where the cop was in a Buffalo Wild Wings, BWW, with my client watching a fight. The cop was standing at the bar in full uniform. When my client walked by him to leave, the cop followed him out. My client was only going to his car to grab his phone charger because he was going home with the bartender. He hadn't even closed his tab yet. The cop arrested him and charged him with a DUI for opening his car door. He then fabricated a story for his report about how my client got into the car, turned it on, and began to pull out of the space to leave the parking lot. He also denied being inside the BWW on the stand, under oath, to my face. Surprise? I talked to the bartender at BWW and got the security tape. It was surprisingly good quality and very clearly showed the cop standing at the bar, watching my client walk out the front door, and then following him 30 seconds later. The parking lot cam also showed my client barely touching the door handle before the cop stopped him. The evidence was irrefutable. The judge threw out the case, and it was a clear win for my client. This case was a perfect example of how sometimes the truth really does set you free, especially when you have video evidence to back it up. Story 12. I'm not a lawyer, but I've been up against plenty of them as a union chief steward. Years ago, we had an arbitration related to healthcare costs. The company spent the better part of a year trying to break us from pursuing the case. The day had come for our arbitration. The lawyer, there were 3 actually, we were up against was Paul Newman's nephew. Anyway, it was my turn to take the stand. His first question to me was presenting the grievance as evidence and asking me what step it said it was on at the top of the page, A grievance process is a two-step system progressing to arbitration if it's not settled. I said second step. Then he smugly asked, and where is the first step? To which I replied, the first step is a verbal discussion. It goes into writing at the second step. He looked hurt, but persevered. A few more questions in, he asked if the entire company getting base-level insurance instead of a premium option would satisfy the contract. At this point, he was hoping I would argue that the base-level insurance wasn't sufficient because he was trying to paint the picture that we were just trying to get premium insurance at a base-level price. I responded with, yes. He looked dumbfounded and asked me again, yes? I said again, yes, that would satisfy the language in the contract. He kind of looked at his other papers he was going to submit as evidence and then muttered, no further questions. I knew at that moment that they had brought no real argument to the table. We got our answers from the arbitrator 6 weeks later during a contract negotiations meeting. It was insanely satisfying watching them read the email during one of the sessions and the immediate shift in demeanor from their side of the table. They got real quiet. We were awarded 100% of the arbitration, full payback for all employees that were being overcharged, and reduced rates for the premium insurance. Story 13. Not exactly a knew-you-would-win moment, but I got a hidden shout-out from a federal judge in a ruling that I consider one of the high points of my career. Here's what happened. Before a hearing for an emergency injunction against the USDA, I was watching the hearing before mine, which was a trademark infringement case. At the end of that hearing, the judge accidentally used a pun and could not stop laughing. She was literally crying. I decided at that moment I was going to intentionally use a pun in my hearing. During my hearing, I accused the USDA of engaging in a shell game by illegally diverting federal funds to an egg industry trade group. The judge called me on it, but laughed heartily. My client won, and the judge even threatened to put the Secretary of Agriculture in jail. A major newspaper reporting on the case said the judge winced at my puns, but agreed with the arguments. When the written ruling was issued, the last sentence stated that an injunction was issued against USDA's use of the funds for any plans they may be hatching. It was an undeniable shout-out and a proud moment in my career. Story 14. I worked on a case involving defective processors. During discovery, we obtained emails from the defendant's engineers who had worked on the processors. These engineers were based in an Asian country, but the emails were in English, as they were intended for U.S. executives. One email from a senior engineer was particularly damning. He laid out the exact defect we were suing over, explaining what the problem was, why it was their fault, and concluded with, "This is big problem. We ship crap to customer." The casual yet candid admission was striking. We presented this email during mediation, hitting them hard with their own words. The realization of their mistake was palpable. The company quickly settled shortly after, knowing they had no defense against their own engineer's blatant admission. Story 15. I knew the cops beat up my client and framed him. They described a knife in his possession that caused them to fear for their safety, but oddly, they never seized it. We won the criminal case and then filed a civil rights case. While deposing one of the officers, he described the knife in great detail. No more than 3 minutes later, he slipped up and claimed his partner told him my client had a knife, but he never saw it himself. I told him, "That's not what you just said," and saw him panic. His lawyer panicked too and asked to see me outside. When we got into the hallway, I withdrew my settlement demand. The case settled for a substantially larger amount within 45 minutes. Story 16. I'm not a lawyer, but I took my old landlord to court when I was in college. They had stolen my security deposit, claiming I had trashed the place. Little did they know, I had taken pictures and videos when I moved in and out, documenting the apartment's condition meticulously. The landlord presented their evidence, a grainy VHS quality recording showing a perfectly clean apartment, actually in better condition than when I had moved in. Then, they dramatically opened the top of the stove, revealing a single piece of elbow macaroni. Holding it up triumphantly, they claimed this was proof of the mess I had left. The judge was not amused. She looked at the landlord, then at me, and it was clear she saw through the absurdity of their claim. I got all my money back, plus my lawyer fees and the filing fee. The landlord was so enraged, she fought against her own lawyer to avoid paying him. It was a sweet victory, standing up against such blatant dishonesty. Story 17. My client was accused of brutally murdering a dog. The cop testified that there was no testing of the blood, no body ever found, and admitted the dog could have run away. The eyewitness claimed she saw the killing down the hallway from the dining room. However, the cop testified there was no hallway and that the dining room was on a different level of the house than where the alleged killing took place. To make matters worse, the person leading the lynch mob against my client around town testified that she had been in the apartment between the two visits by the cop to evaluate the scene. We had no body, a compromised crime scene, a witness who couldn't see anything, and an admission that there was no proof the dog was dead. During closing arguments, I simply said, "Your Honor, I'm asking for an acquittal." The judge agreed, and my client was acquitted.